what I'm going to be trying to do today is to talk about where the problems are in running an internal affairs unit, what you should look out for, some of the things that perhaps you may be able to do to prevent problems arising out of your internal affairs operation. Dan got me started doing internal affairs work about the time that the Attorney General's office revised the internal affairs policy. And one of the things that I had to realize was that internal affairs functions vary dramatically from one department to another. Some departments took the AG guidelines and ran with them. Other departments ran with them partway down the field, and some sort of stumbled out of the box and never got very far, really, in trying to follow what the Attorney General was doing. Things changed a lot over the course of the 8 years or so that I did it before I retired. But what I hope to be able to do today is to bring some of that experience to bear to help you with some of the problems. But I don't want, what I did, the materials, if you've looked through them, are excerpts from, primarily from the Attorney General's Internal Affairs Guidelines. And we start with the fact that what I did was just, as I indicated, just take excerpts from the Attorney General's Guidelines. And the first of these is that since 1996, a New Jersey statute, 40A 14181, provides that every law enforcement agency shall adopt and implement guidelines which shall be consistent with the guidelines governing the internal affairs policy and procedures. And what that statute is talking about is what has now become known as the Attorney General's Internal Affairs Guidelines. So what do we know? We know that not only do you have guidelines from the Attorney General's office that are binding upon you, but also the legislature itself indicated that every department shall adopt and implement guidelines which will be consistent with the Attorney General's guidelines. That being the case, if your department in fact has no guidelines, or for the internal affairs function, or if those guidelines are not in fact consistent with the Attorney General's guidelines, then you have a problem. Right off the top, you have a problem. And think about how that problem could end up. You get sued by a complainant who's unhappy about the treatment that he or she got in regard to an internal affairs complaint. And then you have to go in front of a jury and explain to that jury how come your internal affairs SOP doesn't match up with the Attorney General's guidelines. It's not going to be a very impressive performance. And that jury is probably not going to be terribly impressed, because they're going to find out, one, that the Attorney General mandated that certain things be done, and that a New Jersey state statute mandated that you have policies consistent with the Attorney General's policies. So if you get nothing else out of today, you should go back and review your policies. As Dan indicated, policies are important. It's one of the things that is significant in regard to the racial profiling issue, and it's also significant in regard to the internal affairs function. You have to have policies that match up with the Attorney General's. If you don't, there are going to be issues. In addition, the courts, particularly the federal courts, have begun to focus on the importance of the internal affairs function. Under current case law, law enforcement agencies must do three things with respect to the internal affairs function. First, agencies must implement an internal affairs policy that provides for a meaningful and objective investigation of citizen complaints of police misconduct. Now, that seems like a given. But one of the things you have to guard against is an internal affairs process which sets itself up to be the defenders of the department, because that's not what an internal affairs unit is supposed to be. It may very well serve that function. That is, if it operates properly, it will, of course, defend the department when the department needs to be defended. But if it's run from the perspective that its purpose is to defend the department against allegations made by those evil persons who are members of the citizenry and who might dare to complain about something that the police department is doing, you're setting yourselves up for a problem right away, because the courts want the internal affairs function to be meaningful and objective, and to conduct meaningful and objective investigations. And if you're not set up to do that, there's going to be a problem. Second, agencies have a duty to monitor the behavior of their police officers for incidents of misconduct. And we're going to talk about this toward the very end of my presentation, but I want you to think about that, because it's not enough that you monitor for simply allegations by the citizenry of misconduct. What the AG guidelines want you to do is to be proactive in regard to your management techniques, and want you to proactively look in your department for officers whose behavior may suggest future problems. And we'll talk about that at the end, but it's clear that the courts impose a duty on you to monitor the behavior of your officers for incidents of misconduct. We're not necessarily talking about criminal misconduct here. We may be talking about other things as well. And third, when officers are found to have engaged in misconduct, agencies have an affirmative duty to correct the behavior. That may seem like, again, a given, but those of you who may know the famous New Jersey case of State versus Winnie, which is the case that determined that the prosecutor is the chief law enforcement officer within the county, that case came up and involved the indictment of a police chief for misconduct. And the question in that case was whether the prosecutor, in fact, could do that. What was the subject of the misconduct? The subject of the misconduct was an alleged failure on the part of that chief of police, and this is an old case now, it goes back to 1952, I think. But it was a case in which the police chief was indicted because he failed to discipline his own people. And the prosecutor indicted him for that failure. And the question was whether the prosecutor had that authority, because obviously discipline was an internal matter, and the question was whether the prosecutor could indict for a police chief's failure to discipline his people, and the court said, oh, yes, you can. So when officers are found to have engaged in misconduct, agencies have an affirmative duty to correct that behavior. It's important for county and municipal law enforcement agencies to recognize that as they conduct internal affairs investigations, they do so under the general supervision of the Attorney General. And I'm sure that nobody challenges that. Subordinate law enforcement agencies, including county and municipal police forces, have a duty to cooperate with the Attorney General in order to improve the administration of the criminal justice system, including the efficient delivery of police services. For county and municipal law enforcement agencies, cooperation in internal affairs matters begins with strict adherence to the requirements set forth by the newly revised policy. And again, that means what it says. Being in the ballpark, good analogy during the World Series, I suppose, is not good enough. Strict adherence to the guidelines is what is required. So again, go back and look at your policies, and if your policies don't match up with what the Attorney General requires, then you got to change your policies. And even if your policies do, but if your practice doesn't match up with the requirements of the policies, then you got to change your practice, because again, you're just asking for trouble. In the case of a lawsuit, if it's going to come out in court that what your IA unit in fact does on a daily basis does not match up with what the Attorney General in fact requires.